the regular GOS forces. Whilst not at the top level of the GOS, Abd-Al-Rahman took direct instructions from Minister Haroun and was, and again I quote, an enthusiastic, energetic, effective perpetrator. In respect of mitigating factors, the prosecution alleged that none exist that are of any weight warranting a reduction in sentence. No other circumstance, whether personal, behavioral, or contextual, they argue, reduces Abd-Al-Rahman's culpability. The defense submits that neither a sentence of life imprisonment nor any custodial term that would amount to a de facto life sentence is warranted. Instead, it requests that the Chamber imposes a finite and proportionate term of imprisonment that preserves the possibility of release in light of Abd-Al-Rahman's age, personal circumstances, and degree of culpability, or, if appropriate, the imposition of a fine. The defense asserts that a demonstration of remorse was contrary to Abd-Al-Rahman's defense, and remorse could not thus be expressed. The defense avers that this omission cannot be considered as an aggravating factor given Abd-Al-Rahman's right not to be compelled to confess guilt. As to mitigation, the defense advances several factors which essentially fall into two categories, namely those relating to the offences and those relating to him personally. The first category includes what is said to be Abd-Al-Rahman's subordinate rank, limited authority, and lack of discretion. Second, a mistake of law or duress-type circumstance falling short of a complete defense. Third, specific instances in which he acted to protect or preserve life and prevent sexual violence. The second category of mitigation includes his personal circumstances, including age, health, and family, the absence of previous convictions, and absence of risk of recidivism, his good conduct in general, and particularly after the acts, his role as a mediator and promoter of peace, his medical profession, his expression of sympathy and efforts to compensate victims, his voluntary surrender to the court and cooperation with the court, his exemplary behaviour in the court's detention centre. The representative of the victims submits observations on behalf of 1,000 years. It is not vengeance. Their central concern is that Abd-Al-Rahman must not be allowed to return of the victims, highlights that the victims consider that the sentence must adequately reflect the gravity, scale, and impact of the crimes and their long-term consequences. She indicates that the crimes had a deep and lasting impact on the Fur community and identifies the abuse of authority as raising the gravity and aggravating factors from the victim's perspective, including the particular vulnerability of victims, the particular cruelty of the crimes, and the discriminatory motive and scale of the attacks. As to mitigation, the representative of the victims submits that while some factors may be considered, they merited limited weight. The representative of the victims does not propose a specific term of imprisonment, but submits that, in the light of the victims' views, the gravity and enduring impact of the crimes and the aggravating circumstances identified. Turning next to the gravity of the crime, the aggravating factors, and other crime-specific considerations, as is mandated by these factors in three categories. First, factors considerations which are common to all three operations. Second, factors considerations which are common to all crimes committed in each operation, that is to say, Qudum and Brindisi, Mukja and Dalej. Third, factors, considerations specific to each crime. In deciding on the appropriate sentence for each crime, the Chamber has taken into account all relevant factors or considerations analysed in all three categories. Regarding the first category of analysis, that is to say, factors common to all operations in respect of the gravity of all crimes, these include Abd-Al-Rahman's role as leader of the Janjaweed in the Wadi Salah and Mukja localities, his access to and close relationship with key figures of the government of Sudan at the state and locality levels, and the high degree of planning of the crimes. Aggravating factors common to all three operations include the significant number of victims impacted by the crimes, and the underlying discriminatory motive for the crimes committed predominantly against the poor population. For reasons provided in its written judgment, the Chamber does not consider the discriminatory motive as an aggravating factor for the crime against humanity of persecution or torture as a war crime. Regarding the second category of analysis, factors common to the gravity of all crimes committed in each operation, these include Abd-Al-Rahman's degree of participation and intent, the circumstances of the manner, time, and location of the crimes. And in relation to the aggravating features applicable to the crimes committed during the Mukja and Dalej operation, the Chamber highlights the particular vulnerability and, with the exception of the crime against humanity of torture, the particular defenselessness of the victims. I should say that is because that particular aggravating feature is contained within the definition of the crime itself. Finally, in the third category of analysis, namely the factors specific to the gravity of each crime, these include circumstances of manner, time, and location, nature of the unlawful behavior, and means employed to execute the crime, and the aggravating factors specific to each crime include commission with particular cruelty and commission against particularly vulnerable and defenseless victims. Next, I turn to the mitigating circumstances as advanced by the defence. The arguments which were put forward are fully rehearsed in the written judgment, and what follows is a summary. First, what is said to be Abd-Al-Rahman's subordinate rank, limited authority, and lack of discretion, and also mistake of law or duress falling short of a complete defence. The Chamber accepts these submissions made by the prosecution and the representatives of the victims for, as I say, the reasons given in the written judgment, that these matters were all dealt with in the trial judgment and are an attempt by the defence. Namely, the Chamber rejects the defence submissions under this head. Second, specific instances in which he acted as gave evidence of direct intervention by Abd-Al-Rahman to preserve life, saving the life of a very ill soldier or policeman, it wasn't clear from the evidence, in 1986 in a place called Sungo, and that he gave orders to the Janjaweed to spare the women in Arawala from death, and that he had ordered them to protect women and girls at risk of rape, albeit at the same time ordering the killing of men. In relation to their direct intervention to save the life of an ill soldier or policeman in Sungo, the Chamber finds that this was not extraordinary and could have been expected, considering Abd-Al-Rahman's role as a medical professional in the SAF. It also occurred many years before the crimes of which he has been convicted, were committed, and in another geographical area. As regards his orders to spare the women in Arawala, the Chamber recalls the findings in its trial judgment that a witness explained that that instruction meant that the Janjaweed never killed women. I quote, "Instead, he said, they would torture and rape them." Accordingly, the Chamber does not find either of these two actions constitute a mitigating circumstance. In respect of his state of health and his age now, which, as I said, was 76, the Chamber finds that Abd-Al-Rahman's health, including any illness that may arise in the future, is primarily a matter for the enforcement of the imposed sentence, rather than a factor in the determination of its length at present. It is also as a result of Abd-Al-Rahman's delayed surrender that the Chamber must now consider his advanced age. The Chamber notes the victim's views, which firmly oppose a significant reduction of sentence as a result. Notwithstanding, the Chamber has taken the age factor into consideration in its determination of the joint sentence, albeit to a limited extent. In respect of his family circumstances, the Chamber notes that Abd-Al-Rahman's contact with his family members, all of whom appear to be in Sudan, is severely limited. It further notes that although a convicted person's role as a parent may be a factor to consider in the determination of the sentence, internationally recognized human rights acknowledge that a lawful detention entails by its nature a limitation on private and family life. Abd-Al-Rahman's family, social, and economic conditions, including that he is a provider, are common to many convicted persons and are therefore not exceptional. Accordingly, these are not factors which can outweigh the harm caused to the victims of his crimes and thereby reduce the appropriate sentence. The Chamber finds that the facts that Abd-Al-Rahman does not have any prior criminal convictions or that he is unlikely to reoffend are not mitigating in the light of the 27 counts of which he was convicted. As noted by the prosecution, it is not exceptional in international trials for convicted persons to have should consider Abd-Al-Rahman's, and I quote, positive good character generally, his role as a mediator and promoter of peace. And this should be considered in the light of the evidence presented at trial from several witnesses who knew Abd-Al-Rahman both professionally and personally. However, as submitted by the representatives of the victims, the Chamber finds that good behavior and good character, which is strongly contradicted by the preponderance of the evidence, is insufficient to make a determination on the reduction of sentence. The Chamber does not find that Abd-Al-Rahman's medical profession per se is significant enough to reduce his sentence. If anything, as suggested by the representatives of the victims, his medical profession, and thus his medical knowledge, is considered to be a factor increasing the gravity of the crimes of which he was convicted. This is on the basis that his medical training was designed to save lives, and by his actions he was deliberately running counter to such training, particularly in respect of the crimes he directly committed. In respect of the victims, The defence first points to Abd-Al-Rahman's instructions given to them, his counsel, to seek reparations for victims from the pre-trial stage onwards through letters and meetings with the Trust Fund for Victims, and more recently through communications made to embassies. Second, it submits that the Chamber should take into account the expressions of empathy made by him in various unsworn statements to the court. By its judgment, the Chamber found that Abd-Al-Rahman was responsible for the suffering of the victims, a responsibility he denied and continues to deny. The Chamber finds that Abd-Al-Rahman has done no more than pay lip service to the suffering of the victims and does not accept the defence's submissions that he has, and I quote, paved the way to reparations proceedings, end quote. The Chamber also finds that it is misleading to argue that he will, and again I quote, will insist that the victims be afforded reparations, end quote. As submitted by the representatives for victims without a conviction, trial chambers cannot issue reparation orders. Such an incongruous message to the victims cannot be considered in any matter as part of the reparation process or as an effort to compensate victims. In his last address to the court, Abd-Al-Rahman referred to, albeit very generally, the victims of 2003 and 4, their right to receive reparations, and stated that witnesses' accounts of what happened in Kudum, Bedizi, Mukja, and Delej, and I quote again, was horrible, end quote. The Chamber finds his last unsworn statement to be a calculated and insincere expression of empathy, the more so, as again posited by the representatives of the victims, in that Abd-Al-Rahman's line of defense, both implicitly and explicitly, suggested that the prosecution witnesses, including dual stateless witnesses and participating victims, have either lied or at best negligently failed to state the truth. Accordingly, the Chamber does not find that either Abd-Al-Rahman's actions in respect of reparations or his unsworn statements provide any mitigation warranting a reduction of his sentence. The defense submits that voluntary surrender is expressly considered as a mitigating factor under the rules. According to the defense, Abd-Al-Rahman not only took the initiative of surrendering to the court, but then had to wait for 6 months to meet with representatives of the prosecution. It further argues that notwithstanding the overall delay in his surrender, and notwithstanding that his motives may have been those of self-interest, given that there was never any realistic chance that Sudan would ever have arrested and transferred Abd-Al-Rahman to the court, the only reason that there has been a trial is because he decided to surrender to its jurisdiction. And the defense further submits that the Chamber's decision could, and I use the word that was used, inspire other ICC suspects to surrender if there is a reduction of self-interest and rather cooperate with the court. The Chamber is preferable to no preference. Voluntary surrender is particular circumstances which behaviour in detention should be conducted in trial is expected of any accused sentence. However, such behaviour may be considered to be, according to the registry report, and defence's submission, that good behaviour international detention centre. And accordingly, let's take this factor into account. Principles regarding the sentences to be passed. The sentencing regime of this court requires that individual sentences be passed for each. States that a joint sentence must be passed which shall be no less than the highest individual sentence pronounced. In the light of the evidence in the case as regards the specific gravity of each crime, and those considerations are fully set out in the written judgment. However, for the purposes of this summary, the Chamber highlights first, it finds that the level of Abd-Al-Rahman's participation and intent was identical for both the Mukhtar and Delej operations, and therefore the sentences passed for the crimes committed during those operations are the same. And second, it has not made a distinction between the sentences for the counts alleging murder and those alleging attempted murder on the basis that the evidence shows that those who survived the executions did so by good fortune. The intent of Abd-Al-Rahman was that all should be killed. In determining the joint sentence, as already stated, the Chamber is called to pronounce a sentence in line with the Court's primary purposes of punishment, retribution, and deterrence as defined. Moreover, the Chamber acknowledges the victim's desire for accountability and justice, as well as peace and restoration. In her oral submissions, the representative of the victims conveyed the victims' views on sentence as follows. They say justice for them is not an abstract concept. It's not just a line in the judgment. It's the recognition of a truth that was long denied to them. Because what happened to them was not an accident of war, it was a campaign of extermination, humiliation, and displacement, conducted and ordered by no one else than Mr. Abd-Al-Rahman, and nothing more, but also nothing less. It is what they asked to be reflected in the sentence. Sorry, I'll read that again. It's what they asked to be reflected in the sentence that you would impose on him. Abd-Al-Rahman's conviction is the first acknowledgement that the people of Darfur were not victims of mere intertribal conflict or something akin to that. They were victims of a deliberate campaign. The Chamber made it very clear, orchestrated by those in power, executed by the Janjaweed, led by Mr. Abd-Al-Rahman in the Wadi Saleh region, under the authority of the government of Sudan, even if not specifically ordered by anyone in particular. I propose now to deal with the sentences for the individual offences. Abd-Al-Rahman may stay seated while I go through those, but must stand when I turn to the joint sentence. The sentences have been divided into the applicable groups. First of all, crimes committed during the Khartoum and Bindisi operation. Count 1, attack against a civilian population as a war crime, 12 years imprisonment. Counts 2 and 3, murder as a crime against humanity and as a war crime, respectively, 15 years imprisonment for each count. Count 4, pillaging as a war crime, 8 years imprisonment. Count 5, destroying the enemy's property as a war crime, 8 years imprisonment. Counts 6 and 7, other inhumane acts as a crime against humanity and outrages upon personal dignity as a war crime, respectively 12 years imprisonment for each count. Counts 8 and 9, rape as a crime against humanity and as a war crime, respectively 15 years imprisonment for each count. Count 10, forcible transfer as a crime against humanity, 15 years imprisonment. Count 11, Persecutions as a crime against humanity, 17 years imprisonment. The crimes committed during the Mukjar operation, counts 12 and 13, torture as a crime against humanity and as a war crime, 17 years imprisonment for each count. Count 16, outrages upon personal dignity as a war crime, 14 years imprisonment. Counts 17 to 20, murder and attempted murder as a crime against humanity and as a war crime, respectively, 20 years imprisonment for each count. Count 21, persecution as a crime against humanity, 18 years imprisonment. Crimes committed during the Delege operation, counts 22 to 23, torture as a crime against humanity and as a war crime, 17 years imprisonment for each count. Count 26, outrages upon personal dignity as a war crime, 14 years imprisonment. Counts 27 to 30, murder and attempted murder as a crime against humanity and as a war crime, respectively, 20 years imprisonment for each count. Count 31, persecution as a crime against humanity, 18 years imprisonment. In determining the joint sentence, the Chamber further considered the defence's submissions regarding Abd-Al-Rahman's age, good conduct in detention and during trial, as well as his voluntary surrender to the court. The Chamber has already acknowledged the circumstances constitute relevant consideration in determining an appropriate sentence. However, it also recalls the court's consistent jurisprudence that they should not be given undue weight. In the light of the specific circumstances of Abd-Al-Rahman's case, the Chamber affords these factors only limited weight in determining the appropriate joint sentence. Stand up, please, Abd-Al-Rahman. The Chamber sentences you to a joint sentence of 20 years. The Chamber would have pronounced a higher sentence had it not been for the mitigating circumstances discussed above. That sentence is passed unanimously. The Chamber is of the view that this term is proportionate to Abd-Al-Rahman's specific circumstances, conforms with the purposes of punishment under the court's legal framework, and adequately acknowledges the victim's suffering and harm while recognizing your good conduct in detention and during trial, as well as your surrender to the court and age. It notes that you surrendered to the court and arrived in its custody on the 9th of June 2020. Accordingly, the Chamber orders that the time you have spent in detention from the date of your surrender on the 9th of June 2020 until the date of this judgment shall be deducted from your sentence. You may sit down. That concludes this hearing.
All right, we will have it.